And then there was one. Now that Judge Merchan in New York has denied one of two motions that Donald Trump brought to dismiss or vacate his conviction, 34 felony count conviction in New York in the Stormy Daniels matter. Now that he's denied the first one on immunity grounds, which I'll cover here on this particular hot take, what happens next with the second motion to dismiss, which is for dismissal in the interest of justice that's pending with the judge? And how much closer are we on that giant clock? How much closer are we to having the clock tick to midnight for Donald Trump to be sentenced before he takes office or just after? I'm Michael Popok. You're on the Legal AF YouTube channel. Take a minute and hit that free subscribe button. Let me unpack all of this fast-moving news. Late yesterday, Judge Merchan, as we expected, as I described on Legal AF, denied the motion on immunity grounds that Donald Trump had filed to kick his convictions. He wanted the judge to just toss 34 felony count convictions that a jury of 12 people, 12-0, working hard, fair and impartial, had ruled against him. And the reason for that, the rationale for that, was not that that Trump was immune in terms of the conduct that he allegedly participated in, was convicted of participating in the Stormy Daniels hush money payoff conspiracy and the attempt to interfere with the 2016 election. Not that those were official duties of a president under the immunity decision of the United States Supreme Court. How could they be? He wasn't even president yet. So they couldn't argue. Let me make this clear. They never argued that he was immune. His actions were immune because he was the president, because he wasn't at the time. They argued instead a more esoteric position. They took the esoteric position that some evidence, not all evidence, but some evidence that was presented to the jury over the many weeks touched on official conduct of Trump after he became president. Now, almost the entirety of the cover-up scandal took place before he got elected. I mean, that's the reason for the conspiracy, to get him elected. Some of the actions in paying back Michael Cohen for participating in the conspiracy, for laying out the money in the conspiracy, some of the payback, not the cover-up, the payback happened after Donald Trump was president. And so there was some testimony by people like Madeleine Westerhout, who was Donald Trump's assistant, and Hope Hicks, his press secretary, and some testimony even by Michael Cohen about meeting Donald Trump in the White House, that they jumped up and down and said, official conduct, you can't let that go. And the United States Supreme Court said even official conduct can't be used to prove, in the case of immunity, unofficial conduct. But that's not what was going on in that courtroom. So the judge just ruled, denied on the motion to dismiss or vacate the convictions on immunity grounds. And the Judge Merchan, in a 40-page decision, I'm going to summarize it here for you very quickly, said the following. First of all, he said, Trump, you don't even understand the immunity decision. I mean, that was the first attack. The immunity decision got into the weeds about when you can prosecute someone for official versus non-official conduct, for core presidential functions versus private conduct. And the entirety, really, of the decision is about when you can prosecute and how you divide up the world into unofficial and official conduct, private conduct and presidential conduct, and core presidential conduct, and how you divide the world into prosecutable crime against someone and things for which he is immune. That's the immunity decision. The judge says, that doesn't even apply to us because you already got convicted. So the whole, you're going to impair and impede and undermine the presidency doesn't matter because you already were convicted before you even got elected this time. He said, secondly, you've misread the precedent that's been set by the court, the Supreme Court, about the use of certain evidence. The judge said, I agree with you that if you're trying to prosecute and you're trying to prove unofficial conduct happened, private conduct happened, that's not presidential, that can be tried to a conviction. You are not allowed to use official conduct in order to prove your case. You can't use official conduct to prove private or unofficial conduct. And I understand that too, the judge says, but that's not what happened here. the small pieces of unofficial of conduct within the White House that happened, you didn't preserve it, meaning you didn't even object to it at the time. When Madeleine Westerhout took the stand, you didn't object. And in our business, that's called waiver. You waived it. You can't argue it now. Even Michael Cohen, you didn't raise the issue. You never raised the issue of supremacy clause or immunity at any time when you were supposed to file your papers. But the judge says, I'm gonna give you a break here. I'm not even going to rule, although I could, that your motion, you waived all of your arguments in your motion. I'm going to get to the merits. The judge is like, that's how strongly I feel about this. And how he analyzed it was, you got the immunity decision wrong. You got the immunity decision as it maps onto our case wrong. And fundamentally, the conduct that got presented to the jury in the way of evidence about your time in the White House was very inconsequential given the overwhelming other evidence and witness testimony against you. In other words, it's called harmless error. It's a concept in the law that says you can have an error. There's no error. Let me make this clear, having tried over 35 cases. There is no error-free trial. There's no error-free trial. Errors happen all the time. The lawyers make an error. The witnesses make an error that the lawyers have to respond to. The judge makes an error in ruling. And the law does not require an error-free trial. A fair and impartial trial, for sure, but not error-free, one in which you get due process, yes. And if there are errors, they fall into a couple of categories. We either call them reversible errors, so bad, so fundamental to the trial process and the adversarial process that it's compromised somebody's rights. And it led to a result that would not have happened had this error not been made. That's reversible error. That goes up on appeal and the case comes back or gets thrown out. But harmless error happens all the time. And the judge ruled all of what you're alleging about these various discrete pieces of testimony are harmless error. It would not have mattered to the outcome of the jury and the verdict. Now that's done. Now what happens next? There's one more motion that's still out there. The next motion that he's going to rule on, I imagine before the holidays, could be by the time this particular hot take goes up, is the motion that Donald Trump filed a week or two ago. Which is fully briefed, which is the motion to vacate or dismiss the convictions on justice grounds. Sounds weird. Most states have a version of it where you can go back to a court, the trial court, and say, I'd like my conviction overturned, please, and vacated by the trial court because there was manifest injustice in the process, in what happened, and in all of that. And Donald Trump's main argument is, I won the election, and therefore my bad conduct from before I was president the first time gets absolved. That's the argument. And the judge looked at it, and he's still looking at it. And he's got two pieces of paper, one from the Manhattan DA's office and one from Donald Trump. The Donald Trump one is completely without merit. There were a number of factors that are required under New York law that Donald Trump analyzed. He ignored all of them. I don't even think he even mentioned the case, which the Manhattan DA reminded the judge. He's ignored all of the factors that have to be analyzed. Here are each of the factors, Judge, and why Donald Trump loses. This is not manifest injustice. There is nothing that happened in the prosecution or the conviction by the jury. The evidence was overwhelming. He has acted out and been abusive throughout this process. See, here's where Donald Trump's bad conduct comes into play. He's acted out and been abusive throughout. He's attacked you and the Manhattan DA and their families and the juries and the jurors and the witnesses and so on. He does not have clean hands, we call it. And by not having clean hands, he can't seek to use equity, your equitable powers, Judge, to do justice. He's forfeited his right to seek this kind of motion. That was the heart of their paper. I have been reasonably right in my predictions about this case. There's been some delays in there that we didn't anticipate, and the election we didn't anticipate quite that way. But we are reasonably right. And my prediction, just as it was that the immunity decision was going to be denied, and it has been now, is that this motion is going to be denied as well. So let's say that motion then, Popok, talking to ourselves here, let's say that motion is denied in the next week or two. Before the election, before the inauguration, what could happen? I would implore the judge to continue with the sentencing process. Now, with a caveat, okay? The sentencing process means get get the hearing on the sentencing and impose sentence, which you can suspend until after Donald Trump is done being president, until he's done with his day job. That's what I think is the proper balance, using time. The time is on our side on this one. Not throwing out the verdict. Can't do that. The jury worked hard on that verdict. You have to support a jury verdict that comes out of our public criminal justice system. But you also can't put the now president, in jail for a period of time. But I'm okay with the jail sentence being suspended, have him serve it in 2029. Let's say it's a year and a half or 2 years. Let's say it's 2 years. And some people might jump up and down on the MAGA side and say, you can't have that hanging over his head for 2 years. That'll undermine the office of the presidency and the power of the presidency and the stature of the presidency. Should have thought of that before people voted for a convicted felon to be president of the United States. I think that ship has already sailed. Anybody that's doing business or negotiating with Donald Trump knows what he is. You either believe he got convicted of 34 felony counts of business record fraud and election interference, or you don't. You either believe he's been adjudged to be a sexual abuser in New York twice, or you don't. You either believe that he has to pay a $450 million fraud judgment for 10 years of persistent fraud in the operation of his business in New York, or you don't. And you know what you voted for. Or you may have voted for him for other reasons, obviously, apparently. So I don't think that should come into play. I think the judge should sentence him before Jan 20. I think that sentence should be suspended until after he serves his time, if you will, in the White House. And then he goes right in once he returns to being not the president any longer, to being a normal citizen, abnormal citizen. And then what? And then all the parties can go run off and do their appeals. And they can spend the bulk of 2025 appealing all of their issues. And Donald Trump better have backup lawyers, because he took all of his private lawyers and his private appellate lawyers and he put them into his administration. So now he's got to find backup lawyers. But he does that through 2025. It'll go through the 2 levels of appeal in state court. And then on top of that, it'll end up, after the 2 levels of appeal in state court, it could end up at the United States Supreme Court. So sometimes in late 2025, they're going to have to make a decision at the United States Supreme Court whether Donald Trump can have a sentence hanging over him that he starts after he stops being president. We'll continue to follow it all right here on Legal AF, the YouTube channel, and I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.